The government's argument has always been the H-1B program is being used and abused, utilized to bring in cheap labor, therefore disadvantaging U.S. workers. And that's when the government started putting some guardrails, if we can say that, to the program to allow for this level of abuse not to happen again. And now the latest change, and the most important one that we need to talk about and address today, is what we call the weighted system change. What I would say to employers specifically, be careful. Always keep your information consistent. Make sure that whatever is out there on social media for all the world to see is consistent with what you are giving the government, what you're filing with the government, because site visits have become more and more relevant, and officers are asking more detailed questions. And so not only you don't want your foreign workers visa to be revoked, but you don't want yourself as an employer to be flagged. So the H-1B visa program is a program that is considered the main visa option for workers from all over the world. Congress's intent for the H-1B visa program has always been to attract highly skilled professionals. During the tech boom in the early 2000s, Congress, on two different occasions, pretty much upped the cap. The first time to 115,000 H registration, and the second time it was, I believe, between 2001 and 2003, 195,000 cap registrations. And that was when the government felt there was a real need for foreign workforce or foreign talent to fill the shortage that existed here. The H-1B program became more and more visible, especially in the tech world. And big tech companies started to realize that this could be a really good program for them to attract and bring to the US a lot of foreign nationals, big talent. And at some point, the government felt that the market has been flooded with foreign workers, therefore disadvantaging the US workers, right? And the government's argument has always been the H-1B program is being used and abused, utilized to bring in cheap labor, therefore disadvantaging US workers. And that's when the government started putting some guardrails, if we can say that, to the program to allow for this level of abuse not to happen again. If we think about the program as it continued to evolve, also multiple problems evolved with the program and multiple level of abuses, whether it's on the employer side or also the foreign national. And the most relevant one that the government has tried for many years to stop, this particular level of abuse by big tech companies and mainly placement companies, IT placement companies. Traditionally, how it worked, they would register hundreds, maybe even thousands of people, foreign workers who are focused on IT, programmers, software developers, whatever it may be. And then however many registrations these people will get, these employers will get, then they will file for the H's for these employees and then wait to either have contracts to bring them to the US, place them at clients' sites, or even bring them internally to build processes for them or whatever it may be. So what that did is, number one, it created a heavy flow of lower level tech positions. It disadvantaged the US workers because these lower tech positions were paid less at a cheaper rate. Even though there was a prevailing wage, level one was always a little bit cheaper than what maybe a US worker's position would be paid. So the market flooded with these IT professionals that were either entry level, or lower skilled. And the program always called for skilled workers with a body of highly specialized knowledge, right? So the position is a specialty occupation requiring a body of highly specialized knowledge. And so entry level or level 1 or level 2 was always something that the government viewed as an abuse of the program, and they wanted to stop it. They tried many ways. They scrutinized the program many times over, but that level, this practice did not stop. Congress put the cap of 65,000 H-1B cap registrations, and also defined what specialty occupation ought to look like or ought to be. That was 1990. And then Congress added the extra 20,000 cap registrations for people who have graduated in the US with a master's degree or higher. During the first Trump administration, the government decided that we want to go by a scale system. And simply put, what this meant at the time is that if an employer is registering somebody in the lottery, unless that person is registered under the highest wage level existing at the time, their registration will not be picked first. The wage level is set by the DOL, and there are 4 wage levels related to the H-1B cap registration, level 1 through level 4. And so the government said level 1 is the lowest, level 2 is a step higher, level 3, and then you have level 4, which is the highest prevailing wage. And in order to disincentivize employers from attracting cheap labor, we will focus on first picking level 4 registrations. And if we still have any numbers, we go down to level 3, then level 2, then level 1. So it's like the sliding scale. However, this did not pass. It was not implemented for various legal and policy reasons, and that got stopped. This particular change was not implemented. The next change that followed the H-1B program is what we call the beneficiary-centric process. And what this aimed to accomplish is that also part of the abuse that the government argued some employers were pretty much doing to the H-1B program is one beneficiary would have multiple employers put in a registration for them. So imagine I have a group of companies, 5, 6 of them. You are a great talent and I want to attract you, right? I get all these companies to register you into the lottery. So instead of you getting 1 shot at the lottery, you are getting now 5 shots at the lottery. And that is disadvantage in your neighbor who only had 1 employer able to register them in the lottery. So the government wanted to put a stop to this type of abuse as well. And they said, nope, moving forward, it's going to be beneficiary-centric. So what that means is the beneficiary will only have 1 shot at the lottery. It doesn't matter if 5 employers, different employers, registered him in the lottery. It's him. It's his name, it's his passport number that would be picked once. So he will have 1 shot at the lottery, and if he is picked, all 5 employers can file for him if they choose to, or he can pick and choose which employer needs to file for the registration for him. So he gets 1 shot at the lottery, no matter how many employers register him. And now the latest change, and the most important one that we need to talk about and address today, is what we call the weighted system change. Going back to Trump's first administration, they tried the scale, and that did not go well because it was clear that it was going to disadvantage a large number of the population registering for the lottery. And so now the administration or the government is saying, all right, let's do a little bit of a more balanced and fair process. Let's use a weighted system. So what does that mean for you, the foreign national, trying to be registered, to find an employer, register in the lottery, and get a shot at securing a job in the U.S.? So the way the weighted system works, think of it, you are at a festival and you buy tickets, right? You have those tickets in your hands. So what the government is saying, the weighted system, the way it's going to work, we are going first to pick the 65,000 registrations based on whoever is registered for at level 4. The employer, when registering that foreign national, they have to identify which wage level that position and the foreign national will fit under. So if that foreign national fits on under level 4 based on that position, they will be filling in the US. That person will get 4 tickets. Imagine that person is granted 4 tickets, and then those 4 tickets will go into that bucket that's gonna hold 65. So that foreign national's neighbor is being sponsored by an employer who is placing him at wage level 3 because the position requires wage level 3 and this individual qualifies for that wage, right? That person will get 3 tickets. Those 3 tickets will go into that bucket. And then you continue on. Wage level 2 will get 2 tickets. Wage level 1 will get 1 ticket. So the government also said, if you are a beneficiary of a CAP registration and you have multiple employers registering you for the lottery, and we pick your name, if these employers have different wage levels, they registered you for different wage levels. For example, one of them did register you at level 4, the second one at level 3, a third one at level 2. We are going to pick the lowest level. So even though you had a registration at level 4 and level 3, you're not getting 4 tickets or 3 tickets. You are simply getting 2 tickets into that lottery. So it's very important for not just employers, but also foreign nationals to be aware of that. Again, trying to have multiple employers register you sometimes could not be as beneficial to you as having one employer willing to do level 4 versus multiple, some of which are going to say, no, you're gonna be at level 2 or level 3. You will be hurting your chances at this point because you are not getting the 4 tickets. And then the last thing that the government said in that related to that particular change, it warned employers, if you decide during the registration to place that person at wage level 4 and then they make it into the lottery and you file the H for them, if you decide to file an amendment, bringing that person down to wage level 3 or wage level 2 for whatever business reasons you may claim, we are gonna get you and we are going to either deny or revoke your H-1B petition. So don't play this game, don't attempt it. So the question now is, what other creative ways employers and the legal system at large is going to find to continue to ensure that the talent is going to be available here in the U.S. to employer whenever they need it. And also coupled with something as equally important, which is the $100,000 fee. Even though the $100,000 fee is not part of the CAP registration, but it is related directly to the H-1B program. And so what the government is saying, any H-1B filing that is considered consular processing will be subject to the $100,000 fee. And so if we think about it, imagine employers that used to register hundreds and thousands of H-1B CAP registrations or foreign nationals. Now they're going to think twice before doing that because of the $100,000 that's going to be imposed on each H-1B filing. Even though they may flood the system with heavy registrations, they are going to think twice before they actually file the petition to bring the person in because there's $100,000 involved. Unless that person is in the U.S. and they can do a change of status if they were a student or in a different non-immigrant status. That would allow them to do the change of status to H-1B. One of the positive things that the government has implemented as it relates to the H-1B program is the H-1B founder rule, which I think benefits foreign founders in the U.S. here greatly. And so that particular rule said, if you are an H-1B founder, someone who owns a company in the U.S. or want to start your business in the U.S., you have your startup and you own more than 50% of that company, we will consider you to be a founder and you can apply under the H-1B founder category. We will grant you 18 months initially instead of 3 years. As a startup founder, when you think about your company, what does my company need to allow it to be eligible to sponsor me for the H-1B? The first thing is, of course, you need to form your company. You need to apply to do business in the state where you are going to have your headquarters. You need to have an office. Previously, the past few years, starting with COVID and because of COVID, a commercial office was not something that is required due to the COVID situation. And so USCIS was a little bit lenient and flexible with that. But now, they're starting to become more strict. They're looking at filings and they're questioning where's the offices. They're doing site visits. They're trying to pretty much look at every special regulatory criterion related to the H-1B and making sure that that company is compliant with it. So I would say you do need to have some kind of commercial office location. A WeWork would work, a sublease. If you have a friend that already has an office, commercial office, you can do a sublease with them. And of course, you need to have what we call a minimal viable product related to your business, to your company. It cannot just be an idea. It needs to have a little bit more, not too much. You don't need your product to be commercialized, but enough of a prototype or something, some activity related to what you're building to allow you to have a good narrative for your H-1B cap petition, right? And then, of course, having some money in the bank to show the government that you can pay yourself is also important. You don't need to raise millions, but you need to have a little bit of money in the company bank account to allow you to tell the government, yes, my company is set up properly to sponsor me for the H-1B cap. And so that takes me to my next point. You're the founder, we're talking and I'm explaining that to you. You're gonna say to me, but with this weighted system, what chances do I have? I'm a student, I'm still in my OPT in STEM, and I just started my company and I barely have any money. How am I gonna put myself at level 4 when you just told me if I do that to get in the lottery and then I file and then I file an amendment later on, my petition could be revoked. So how am I gonna fix that? Well, one way of fixing it is think of hourly rate. You can be at wage level 4, but you don't have to work full-time for your company, especially if you can find a different employer as well to work with them and concurrently continue focusing on your idea and building your idea. So at least you have the stability of a full-time job, and then you have your company that you are focused on a part-time basis. So go the hourly rate, level 4 hourly rate, 15, 20 hours a week, that could be doable for you. The other creative idea that you may be thinking of, or I may help you get to, is maybe your office should not be in Palo Alto. Maybe your office could be in a different city with lower wages, because as we all know, prevailing wages are applicable to counties and metropolitan statistical areas. So if you are in Palo Alto, your level 4 prevailing wage is way much higher than if you are in Austin, Texas. That's another cool city to be in. Or if you are somewhere in the suburb of New York, or if you are in Philadelphia or somewhere outside of Boston. Don't pick those big cities where wages are extremely high and then try to allow you to have that flexibility. Put yourself at level 4, position your company in a place that is reasonably lower prevailing wage, even if it's level 4, right? Think about creative ways how you can set yourself up as a founder to succeed at the CAP registration and at the same time actually be able to support your idea and advance it. So many foreign nationals who are currently students here in the US may be thinking now, okay, I'm doing my graduate program. I have maybe a couple months left. If I have a prospective employer could register me in the lottery, and by the time I'm ready to file it, I would have graduated and I have my master's degree. But having a master's degree, being a newly graduate with a master's degree, my employer may not be willing to put me at level 4 or may offer me a position that's not equivalent to level 4. So how am I gonna benefit if my chances are gonna be lower if I'm placed at level 1 or level 2, depending on my position, right? How can I up my chances? So one way of doing it is think about it from your background perspective. So before you came to the US as a student to do your graduate studies, what did you do abroad? Did you have a bachelor's degree? The answer is most likely yes. Did you work after you graduated and come in here? Did you own a company? Did you work at your parents' company? Were you employed by Amazon or Facebook or LinkedIn, whatever it may be outside, for many years before deciding to come to the US? If the answer is yes, then you may be well positioned for a level 4 or level 3, which still also give you a good shot at the lottery, 4 tickets, 3 tickets, right? So that's not a bad option as well. But you can rely on your bachelor's degree and the years of experience that you already accumulated in your home country before coming here to the US as a student. Now, remember, as an H-1B holder, you can continue your studies in your graduate program. Of course, I have to say, always discuss with your school. Make sure you let the school know that at some point you're thinking you may change status from F1 to H-1B. Some schools may have strict policies that they will not allow students to be in any status but F1, even though the law says as an H-1B holder, you can go to school and attend classes. This is also a creative way for you to be able to get yourself in the lottery and try to be a little bit at the higher level in terms of the prevailing wage. What I would say to employers specifically, a lot of the employers out there, especially in the tech industry, when they post ads for specific jobs, a lot of them do not mention what degree requirements should be imposed. They focus on the experience, they focus on those specific skills, etc. And so I would say, if you are an employer looking to sponsor foreign workers for the lottery, always keep in mind what you put out there as an ad for the same position that you're sponsoring that foreign worker for. If you're putting that foreign worker at level 2 and yet your ad is saying this position requires a bachelor's plus 2 years, right, which is level 1, or 3 years, which is level 2, be careful. Keep your information consistent. Make sure that whatever is out there on social media for all the world to see is consistent with what you are giving the government, what you're filing with the government, because site visits have become more and more relevant, and officers are asking more detailed questions. Not only you don't want your foreign workers visa to be revoked, but you don't want yourself as an employer to be flagged.